Okay. My name is Evan Gessner. I'm an attorney from Lexington, South Carolina, where I handle civil rights claims and myriad bunch of other things that come up. This is my first year judging a national level We the People competition. I've been doing it at the state level for a number of years, but I'm excited to be here and look forward to your presentation.
Thank you.
And I am Francine Engel. I am from Maryland, and I am a political scientist, and I focus on American constitutional development. And I currently work with the Maryland Council for Civic and History Education.
And I am Jocelyn Broman. I'm an alumni of the program. I competed at nationals in 2006, which is basically several lifetimes ago. I then went to law school, and so I'm also an attorney, and I currently work on Capitol Hill for Representative Don Young of Alaska.
Well, I'm Eli Thomas, and I'm a senior here at Green River High School. I'm a little off-frame, so I'm going to scoot in a little closer.
Hello, my name is Olivia Nielsen, and I'm also a senior. It's wonderful to meet you guys.
And my name is Jared Westisco. I'm also a senior at Green River High School.
So make sure I'm not muted. Okay. We have Unit 3, Question 1. Oliver Wendell Holmes once said, "I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review?" Go ahead and start whenever you're ready.
In Federalist Paper 39, James Madison provides the belief that the Supreme Court would clarify controversies relating to the boundary between two jurisdictions. With judicial review, there have been occasions in which the powers of both systems, state and federal, were limited and expanded.
For example, during the early Great Depression, the Supreme Court initially invalidated many aspects of President Roosevelt's New Deal because it was deemed that too much power would be given to the federal government. However, by 1942, President Roosevelt had appointed 8 out of the 9 Supreme Court justices.
This, in the end, expanded federal power significantly. By the 1980s and 90s, President Bush and President Reagan had appointed new Supreme Court justices, such as Senator Scalia and Senator O'Connor, who held the intentions of once again limiting the federal power that had been expanded during the Great Depression.
More recently, in 2015, the Supreme Court ruled in Wyoming v. Hodges that all states have to recognize marriage between same-sex couples. The Supreme Court's 5-4 decision is overruling of what many states believed and advocated for. Thus, overarching debate between the state and federal governments was diminished by the federal government's rulings.
The Supreme Court, in nearly all ways, is a counter-majoritarian practice. 9 justices are placed in the court, all with lifetime positions. These 9 people are forced to decide difficult and often critical decisions regarding the United States citizens. However, the court being counter-majoritarian is not a negative trait.
Studies and surveys conducted by the UCLA Williams Institute suggest that of 10 years ago, just over 3.5% of US adults identified as LGBTQ+. So when the Supreme Court decided to overturn v. Hodges, they were helping just under 4% of the total US adult population.
Most poignant example of counter-majoritarianism, however, is seen by the Supreme Court case Roe v. Wade. Upon analysis of the First, Fourth, Fifth, Ninth, and 14th Amendments, the Supreme Court ruled that the ability to terminate a pregnancy within reason is constitutional.
When the decision of Roe v. Wade was released in 1973, 46 states had to readjust their health clinics and policies to follow what was ordered. Although the overall decision was to help nearly half of the population, females, the decision went against what many already believed and practiced.
By securing the rights of minorities such as LGBTQ+ and women populations, the Supreme Court is using judicial review in a counter-majority practice. There has been scrutiny, debate, and analysis on regulations within the Supreme Court's power of judicial review. Mr. Brad Cox declares that the current lack of regulation is, quote, pretty tenuous at best.
As it stands, Judicial review is not explicitly stated within the Constitution. Rather, it is implied in Articles 3 and 5 and was established in the landmark case of 1803 Marbury v. Madison. In order to limit judicial review, two new factors need to be put into place.
Supreme Court judges should be voted in by the people and hold a term limit of no more than 2 presidential terms after they are elected. This way, there's continual turnover within the Supreme Court that is approved by we the people, as politics continue to change and shape the future.
Then, in order to have an additional check on the judicial review, Congress should have the ability to validate or veto, if necessary, a Supreme Court's rulings. An example of an overextension of power by judicial review is the landmark case Roe v. Wade.
The Supreme Court declared that any state law which prohibits a woman from an abortion is unconstitutional, therefore introducing a new federal policy. If both term limits and a congressional vote veto are put into place, then legislating from the bench would not solely burden the Supreme Court, while also providing another check for constitutionality.
All right, thank you. Now, if I heard you correctly, it was Ms. Nielsen, you said that Supreme Court justices should be elected by the people. Is that what you said?
Yes, I did, sir.
Okay. So first question I have, and of course, this isn't just to Ms. Nielsen, but to the entire panel. Can you see any problems that might present?
Yes, I definitely can. Just because first off, an election within the people, we can definitely see it would go especially towards the political parties that the people are voting for. Whatever political parties are more popular that year would most likely be the political party of the candidate that is voted in. However, if the president is putting in the Supreme Court justices as they are now, it is not really representative of what we the people want. It is more representative of what the president, what the federal government wants at that time.
It would inherently remove the Supreme Court from their position of isolation. It would stop the Supreme Court from being this isolated, we know the laws and here's what we stand on them, and it would immediately bring them right back to the political rat race, which is both a con and a pro. So
Right, that, I mean, don't we want the Supreme Court to be insulated? Or isolated, I think was the word you used.
We do to a point. However, at multiple times, they're not representative of we the people. They are a counter-majoritarian practice. And so ultimately, if we have them voted in by we the people, we would be seeing more of what we want for the Supreme Court and what the Constitution says.
it would be easier to have this give and take with the Supreme Court and less of a, it would help speed up the Supreme Court a little bit more, and speed comes with pros and cons as well, because we would get more in line with the political views of the people, but that might be a little too fast in some cases as well.
I have a clarification question from your presentation. How are you using the term counter-majoritarian? How do you understand that term when we say asking if the court is counter-majoritarian? Because I thought from some of the things you were saying that you might be looking at it as it's representing minority views, or is it that they're not being, the decisions aren't being made by a democratic branch of government?
So the way we viewed this and the way we wrote our question and analyzed this was ultimately for counter-majoritarian is they're not representing the full views of the people. So at times we are representing the minorities. So even though it might be a good decision, it does not represent all of people. For example, the LGBTQ case, it is an essential part of what we need within America, but most of us are not LGBTQ+. However, so that is counter-majoritarian, and that is how we viewed that within the case. Does that answer your question?
Yeah, so if the majority of the population didn't support a view, you're okay with the court making a decision even though it's not popular with the public?
If it is constitutional, then it is within that right, yes.
Okay. Thank you.
Thank you.
So let's go a little bit deeper on this. why don't we just limit the court from answering political questions and we somehow, I don't know how, please tell me if you know, we make Congress actually answer the political questions. So it seems like that would solve the problem that you're talking about here, right?
Yes, it would to a point, but our whole entire system of government is based around balance. We do have the balance of the Congress. We do have the balance of the Supreme Court. They do have each of their roles, and each role is important. And there is a reason that these roles are spread out, not just within Congress or just within the Supreme Court. So although it would solve some things, I think the balance is necessary.
So what balance are you talking about then? Are you talking about that we do need some sort of counter-majoritarian institution to balance the directly elected president and Congress?
I think so, yes. It's nice to have something isolated, but it cut to a point where the Supreme Court is this counter-majority and isolated group. It's good to have it be able to act in opposition of the general public, but it shouldn't be as isolated as it is. Going right back to that balancing act, it's something that we want to have mostly isolated, but still something that can evolve and grow with the times, not get stuck with 80-year-old judges who aren't always in line with the current generations.
Yes, so ultimately, as you said, with the balance, each role, the Congress, each Supreme Court justice, they each have their role within the government system. And that balance is very necessary in creating the system that we, the people, want and need within the government and the Constitution. That's what keeps our government running.
So how about we kind of limit what judicial interpretation, not judicial interpretation, rephrase. What about how judges interpret the Constitution? What if we say we're going to put like 5 of this type, like living Constitution, we'll put 5 of the originalists, and then we'll just let them fight it out on all the cases. But at least all the representations are up there.
I think that would be very beneficial in some ways, but in other ways it wouldn't. So yes, we would get all of the views, but that doesn't necessarily mean that, like, if we the people don't elect them, that doesn't mean they're representing what we want, even if they do have most of the views out there. Next mention.
Okay.
Does that kind of answer your question?
It does. I mean, oh, Evan, did you have something?
I was going to ask how much time we have left.
We want more questions.
We are just now at the 1 minute mark.
Oh, excellent. We have more. Sorry.
All right, somebody's got a question. Ask it quickly.
Go ahead. Did you have a question, Evan?
I did not. No. Sorry.
Okay. Okay. Is there anything that you would change in the judicial nomination process or in the judicial confirmation process?
Well, as we said, we would prefer that the justices be elected by the people so that they would represent the entirety of the people's wants for the Constitution. But at the same time, because of the way that it's at now, it kind of is, the Supreme Court's becoming more partisan because they're being appointed by the president. So with the election process, we'd be able to appeal to what the people want instead of just what the justices want.
I think it would be an interesting concept to, as long with that, also institute some sort of qualification basis. So you have to have so many years within the political system, because while we did have that, we're getting to the point now where people are becoming less qualified on the Supreme Court. But it would be an interesting idea to have some sort of qualification base that you have to have achieved this much experience before you are able to be nominated to the Supreme Court.
Great job, guys.
Yeah,
Good job, Ed.
let's give the students some congratulations on their hard work and participation today.
All right, right, guys, great job, great job. You know, and I think I'll look at my panel, correct me if I'm wrong, but they might be the first ones today to suggest there be some minimum qualification before you can get nominated to the Supreme Court. And I don't disagree with that at all. Y'all did a great job. And, you know, one thing that y'all have done is, I think, taking a position that's probably opposite to anything I would have taken. And I think my co-judges here too. And that's the good thing about this competition, is it's not about right or wrong, but it's about picking a side and defending it, and giving examples, you know, giving reasoning, and you've successfully done that. I was looking through my notes, see if there's anything I wanted to comment on specifically. Yeah, talk about electing judges at oftentimes at state lower levels. The judges are elected by the people, and I've seen in some areas where the judges have re-election campaigns and they have political ads, and so a judge trying to get on the bench is just like the mayor of your town trying to get re-elected. The one commercial I'm thinking of, the judge held himself out as the hanging judge and promised that he was going to be hard on crime and have as many people sent to death row as he possibly could, which to me seems troubling. So I don't know that I want judges popularly elected. I think that can be a problem. But again, that's an opinion and that's open to debate. So again, great job for taking a position and sticking to your guns.
Thank you.
Thank you.
Yeah, am I on mute? No. Okay. So yeah, I also wanted to echo that. We haven't really heard anybody come out and say that they wanted judges elected by the people. And then to just, I think you said it was like 2 presidential terms and they'd have to leave. And then you also, so that you're the first group that I think that has said that. And I like, when you hear a bunch of these things, it's nice to hear something new. And I applaud you for sort of taking a more non-traditional approach to responding to the question and, defending your position. If there was one little thing that I would say maybe with your prepared statement, I would have liked to have heard a little bit more on the history. I mean, because you started off with Federalist number 39, and then you kind of jumped all the way to the New Deal, like within 2 sentences. So I would have liked to have heard more about, 18th century, 19th century issues of what was going on there before jumping all the way to the New Deal. I know feels like a lot's not going on until you hit that point maybe. But I would have liked to have just maybe had you develop that a little bit more in your statement. But I thought you did a fabulous job.
Thank you.
Yeah, you guys did a great job, especially taking a position, like you just stuck with it, which is thoroughly impressive because we're all just like, wait a second, let's think about this. And so I would definitely applaud you on that. The one thing I would consider, like, as you're continuing to think about these issues in the future, is I wonder if we allow the Supreme Court justices to be elected, one, we have to change the Constitution, and that's going to be a challenge. And 2, does that actually change any of the partisanship that actually is already occurring? And so that's a really good question that I hope you guys are getting a chance to think about, because we have seen every state is a little bit different. So I'm originally from Wisconsin. Our Wisconsin state judges are elected, and it can be they can be some pretty nasty fights. There have been a couple that have been just absolutely terrible politically. But I attended law school in Iowa, and what they do is they do a retention election. So every few years, the judge that had been appointed by the governor, it has to be reelected and retained. And usually so that gives an opportunity to remove them, but they could stay. So it kind of is a different way of looking at it. So as you guys are like looking at this issue, like immediately jumping to election of judges is like a huge step. So looking at like those incremental things that might change the process and maybe include more political popular will in those judicial opinions just say if they would do it. Like that gives us more to like kind of play around with as well. Yeah, but otherwise, no, but you guys did a great job of sticking with it, and your reasoning was pretty good. And just to make sure, look at how you're arguing with the counter majoritarian versus will of the people, because there was a kind of saying, like, you're saying counter majoritarian is good, and then you're also saying, but we need less counter majoritarian influences in government. So, I mean, lawyers, we make opposite arguments all the time. So our argument in the alternative usually is kind of part of it, but it doesn't kind of line up with everything that you were saying. So just as you're like thinking through the process, all of these different things kind of feed into each other. So you guys did a great job discussing everything, and I hope you get a chance to do some more. So thank you.
Thank
Thank
you
you.
so much, you guys. We really appreciate your
Great
time.
job.
Thank you.